Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have been, over the course of the past week, providing you with discussion points, presentations on this YouTube channel and also on our podcast, Idaho versus Kohberger, addressing the two very important orders that Judge Megan E. Marshall signed October 1st, 2025, that operates to prevent, enjoin the city of Moscow from releasing certain records from the Moscow Police Department's investigatory files into the catastrophic events that happened at 1122 King Road. If you have not yet had an opportunity to review those prior episodes, please do, because we are now going into the very last episode of this continuing series covering the last two pages, pages 12 and 13 of the Memorandum Decision granting in part plaintiff's complaint for permanent injunction. In our last episode, the court was explaining, amongst other things, what was being granted, what was not being granted, because as you can see from the title, this judgment grants in part, but it also denies in part some of the things that the plaintiffs were looking to prevent the city of Moscow to release. Going into the final two pages, we see now explaining that plaintiffs must show threatened or actual irreparable harm, and that there is a reasonable expectation that the wrong will be repeated. From the pleadings, the city does not dispute plaintiffs' claim that they have suffered irreparable injury due to the initial disclosures, even in their redacted form. Instead, the city contends, quote, it has made the only decision available to it under Idaho law, end of quote, by blurring the students, and requests that the court find the initial redacted versions of the investigatory records to be publicly disclosed. The court in the next paragraph says irreparable injury is any injury that is impossible to remedy or repair. Plaintiffs have set forth undisputed evidence that they have suffered and will continue to suffer irreparable injury, including extreme emotional distress because of the city's release of certain records. More specifically, the injury sustained has physically manifested itself through sleep disturbances, shaking, and sobbing. While it is likely plaintiffs have suffered these same or similar injuries prior to the city's disclosures due to the trauma that they've endured from underlying circumstances over the last several years, the city has not disputed that its initial disclosure of video, audio, and photographs in their redacted form caused plaintiffs the irreparable injury claimed. As such, plaintiffs are entitled to relief. So if I could just interject a few comments, a few opinions here. The court here is explaining what irreparable injury means, that it is harm that can't be remedied, it can't be cured. And so then the court has explained that not only has the plaintiffs likely suffered some of the injuries that they've stated here after coming across one of these even redacted photographs. The court has basically found that the city hasn't disputed that its initial disclosure of video, audio, and photographs redacted caused plaintiff this irreparable injury claimed. And so therefore, plaintiffs are entitled to relief. Now the court goes to section 4, conclusion section. For the reasons set forth above, the city's disclosure of certain investigatory records would constitute an unwarranted invasion of personal privacy. Plaintiffs have established the disclosure of such records has caused irreparable injury, and further disclosure will result in the wrong being repeated. Therefore, plaintiff's complaint for a permanent injunction is granted in part. You see here Judge Megan E. Marshall as district court judge, her hand signature, hand date, and then on the final page, this is what you will typically see in all court filings, including orders. This is the certificate of service. And this is where the clerk of court's deputy clerk will typically certify that she is certifying copies of the memorandum decision granting plaintiff's complaint for a permanent injunction were delivered to the following. And then she goes into the certificate of service list. It was delivered to Leander James, who is the attorney for the plaintiff, Leah Batista, who is the Moscow City attorney in-house, and then Bentley Strongberg, who is an outside counsel representing the defendant, the city of Moscow. And that this also happened on the 1st of October, 2025, and signed by the deputy clerk, as you see here. Some final observations, ladies and gentlemen. I want to go up to the conclusion section. This ties up why it is this is called a memorandum decision granting in part, not 100%, but in part, the plaintiff's complaint for permanent injunction. It is because the plaintiff didn't get everything that they were asking for. And again, to learn what it was that specifically the city of Moscow can continue to release versus which they are barred or prohibited from releasing, please listen to our previous episodes of this continuing series, and it will guide you through this memorandum decision. Speaking of which, this document is 13 pages long, including the certificate of service. It is very long. It is chock full, as lots of legal filings are in many of the cases that you're probably following now. Maybe you followed in the past, like Idaho versus Kohberger when it was active. You will see that these filings many times have a lot of legalese. It will cite to statutes, as this one did. It will cite to federal law. It will cite to state laws, this one did. It will cite to rules of court, procedure, and other matters, as well as then applying the facts of the case to the law for the court to come up with the ruling, as the court did here. A tip: when you are reading these court documents, I recommend that you, if it's a long document like this one is, go to the last page, to the conclusion section, because that will help you to formulate your brain as you're going through page by page of this very heavy material in a lot of cases. It will tell you how the court ruled. And then from there, and there may be a few statements in there like Judge Marshall is putting here, that will then help you to frame the rest of the opinion beginning from the start. Sometimes there will be a synopsis of how the court ruled on the first page. Sometimes there won't be. Either way, I recommend looking at the conclusion section. So here we see the why, which is this memorandum decision, for the what happened, the final judgment that was granted in part, granting this permanent injunction. This now concludes not just this episode of the Indie Zone, but also our multi-part analysis of the memorandum decision granting in part plaintiff's complaint for permanent injunction. As always, these are pure comments that we give under the First Amendment, pure opinions, pure speculation. If there's anything, any opinion, any comment, any speculation that you would like to add, please do so here. Until next time, this is Kathy. Thank you for joining us here today.